Rules Committee come to order, and thank you very much for joining us this beautiful day where the Rules Committee reconvenes for the opportunity today to hear from members about a bill that will be on the floor, H.Res 970, insisting that the Department of Justice fully comply with the requests, including subpoenas, of the Permanent Select Committee on Intelligence and the subpoena issued by the Committee on the Judiciary related to potential violations of the Foreign Intelligence Surveillance Act by personnel of the Department of Justice and related matters. Gentlemen and ladies, that is why we are here today. Oversight of the executive branch is one of the House's most important responsibilities and authorities. We as a body support compliance with the committee's legitimate oversight requests and subpoenas. The Department of Justice has not fully complied with these requests to date, many of which stretch back many months. This resolution is tailored specifically to the requests and subpoenas issued by the United States House of Representatives and their committees. We're bringing this resolution to the floor to give members the opportunity to speak for the House's oversight authority, to reiterate to the Department of Justice of the United States the need to fully comply with our legitimate requests. I find and have found during my time as a member of Congress that Article 2 personnel tend not to be open about their business in a transparent way. They do not share information. They are not forthright in dealing with the other branches of government. And a court would have the opportunity to have them show cause why they should not be put in jail pending properly performance of those duties. The House of Representatives does not have that. We do not have a police force. We are a legislative body, which is a co-equal branch with the other two branches of government, Article 1, Article 2, and Article 3. And I find that it is disappointing, whether it's a Republican or a Democrat in office, whether it is a House or a Senate, that elected officials need to be dealt with honestly. There are ways to do that. There are SCIFs and other private matters where there can be discussions, but there also needs to be full compliance when a legitimate request is made by a body of this House. And I find that that is why we are here today. And so before we move to our distinguished panel, we will move to the distinguished young gentleman from Massachusetts for any opening statement he'd like to make, and then we'll come back to you and welcome our distinguished guests that are with us today. Gentleman's recognized.
Well, thank you, Mr. Chairman. And can I inquire, is Mr. Goodlatte going to testify today, or?
Thank you very much. The people who will testify today are the gentleman from North Carolina, Mr. Meadows, who is the author of this. And Mr. Jordan will be a representative of the committee.
You're representing Mr. Goodlatte.
He would, the Judiciary.
Yeah. Well, I just have a few opening remarks. First of all, I want to say to Chairman Sessions that, as I've said many times before, that we are living through the most closed Congress in the history of our country. The record is terrible. A record-breaking 89 completely closed rules, 0 open rules, and this will be undoubtedly another closed rule. I don't know if you guys on the Judiciary Committee know this, but legislation from your committee has gone to the floor under a completely closed process more than any other committee, with the exception of the Financial Services Committee. And I don't really think that that's a record to be proud of. This will be the 14th time this Congress that you will have decided that no other member can offer an amendment to your legislation. No ideas are welcome. You take it or you leave it. I think it's a terrible way to legislate, but this is the way you guys have chosen to move forward. Now, I'm talking about the terrible floor process, but what happened in the Judiciary Committee yesterday, as I understand it, where the minority was absolutely railroaded by the majority, was even worse. Our members sat and waited over an hour for that meeting to finally start, only to be cut off at every turn once it did. The majority overturned a correct parliamentary ruling. I guess rules don't matter anymore. Then they moved the previous question, cutting off debate and pending amendments, and even parliamentary inquiries and I guess debate doesn't matter anymore either. But this whole thing was heavy-handed and frankly undemocratic. To the chairman of the Rules Committee, we often hear that we get to speak in the Rules Committee as much as we want. Quite frankly, I'd rather have more amendments and less speaking, but we don't cut each other off up here. It's called basic civility. But that is not what happened in the Judiciary Committee. The majority treated their colleagues with tremendous disrespect. And what is the response of the Rules Committee going to be? Well, this committee has decided to employ emergency procedures to take up this resolution, to rush it to the floor under a closed rule, and essentially by doing that, you're enabling the Judiciary Committee's bad behavior. In fact, you're sanctioning the terrible way that our colleagues were treated. So let's talk about the resolution, the emergency resolution. This so-called resolution of inquiry is nothing of the sort, since it is written in such a way that it is unenforceable and factually incorrect. It's based on a few of the most extreme Republican members' unfounded theories and improper and unworkable demands for the Justice Department to produce highly sensitive documents related to ongoing criminal and counterintelligence operations, some of which the House has no business requesting, quite frankly. And let's talk about what this Congress has not done in terms of oversight, because I do believe we have a role in oversight here. Republicans have refused to examine foreign payments to the Trump Organization, private travel by members of this administration, HUD Secretary Carson's $31,000 dining set, the security clearance process, which, among other things, provided a preliminary security clearance to a guy who was a domestic abuser, the countless scandals involving EPA Secretary Pruitt. I might go on and on and on about about things that should be investigated. And quite frankly, if they were happening under the previous administration, you'd be having hearings nonstop, 24 hours a day. But here, it's hands off. It's making believe nothing's going on. I ask unanimous consent to insert in the record a piece by Kurt Bardella, who served as a spokesman for former Republican House Oversight Committee Chairman Issa.
Without objection.
In it, Mr. Bardella said, and I quote, "To this point, the Trump administration has been protected by House Republicans unwilling to look the other way." The Trump administration has been protected by House Republicans willing to look the other way in the face of unethical conduct that under President Obama they would have investigated relentlessly, end quote. This resolution is an insult to the integrity of this institution, and it's nothing more than another attempt to undermine the credibility of the Mueller investigation. But again, I would conclude by saying, at some point, if we want a more collegial environment here, then that means that everybody needs to be treated with some respect, including members of the minority. And unless I'm mistaken, from what I understand what happened in the Judiciary Committee yesterday, the minority was treated quite shabbily, and I think it's inexcusable, and I yield back my time.
Thank you very much. Mr. McGovern, I want you to know that during the years that we've had a chance to be together, I have always encouraged you, Judge Hastings, to bring these discussions directly to the Rules Committee. We meet on a regular basis. We do have, as you know, the opportunity to meet with every single committee, and that in that process we attempt to get realistic people who are able to speak not only on behalf of the committee to answer those questions that come from this committee, but also you have an opportunity to provide your best witnesses with an opportunity to offer clarifications to that. I appreciate your comments today. They are not taken lightly. They're taken in the spirit in which you meant them, and I understand, because what you want is this body to be fulfill its responsibilities, not only to Article I, but to the Constitution of the United States, and I appreciate your feedback very much. Gentlemen, welcome to the Rules Committee. We're delighted that you're here. The opportunity for us to be here together today will allow each of you a chance not only to speak. I'm going to, if I get the opportunity to, first go to the distinguished gentleman from North Carolina, then the distinguished gentleman, Mr. Nadler from New York, and then would open up with any of you, Mr. Perry or Chairman Jordan, if you would choose to make a comment also. We're going to go in that order unless someone chooses otherwise. Without objection, anything you brought into a committee today in writing, we'd appreciate the officer of stenographer for getting an opportunity to complete the record as appropriate. Distinguished gentleman from North Carolina is now recognized at this time.
Mr. Chairman, thank you so much for offering me the opportunity to address this committee today, and certainly my thanks to the entire committee, both Democrats and Republicans, for your tireless work. Obviously, being on the Rules Committee is something that requires a lot more time and effort than other committees, just because of the very nature of your important work. And so I want to thank the chairman for his leadership, for his willingness to hear the case as it relates to really proper oversight. Gentleman from Massachusetts speaking earlier, the ranking member of this committee, probably knows well that transparency is a critical issue for me, and that I've cited many times in oversight and government reform with my Democrat colleagues to provide that, even in this administration, as late as 10 o'clock this morning with the gentleman from Maryland, Mr. Cummings, because we have a fundamental role where we've got to make sure that we produce and conduct proper oversight. And this issue would not have reached this particular point had there not been an adequate response and even a willingness to comply in a reasonable manner by the Department of Justice and the FBI. The gentleman from Ohio, Mr. Jordan, and I have made countless inquiries of the Department of Justice dating back to November of 2017, when the initial letter that is in this resolution was first given to the Department of Justice, asking them to comply with information. But here we are today. Now, and let's think about this. Here we are today with a subpoena that was issued from the Judiciary Committee, giving DOJ a very short time frame to respond. And yet we are at 98 days since that subpoena was issued, and still there are tens of thousands, not one or two, not 100. There are tens of thousands of documents that have yet to be produced to Congress. Now, none of us are interested in revealing sources and methods. We understand that we've got to protect those national security interests. Yet the very documents that we've asked for fundamentally are critical to our oversight role. And so not only have we not received it there, but we've sent multiple letters. I personally have had over 150 phone calls with the Department of Justice, begging, pleading, encouraging them to get the documents to us. Even on item 7 of the subpoena that Chairman Goodlatte sent in March, was requesting certain documents that the ranking member of Judiciary and I are in a transcribed interview today, interviewing a particular witness. It would have been very helpful to have those documents before we entered into that questioning of a witness, but yet here we have potentially 50 to 60,000 documents that relates to that one specific schedule, and only 1,400 documents have been delivered. 1,400 out of a universe of 50 to 60,000. Gentlemen, that's not compliance, and this Department of Justice, yes, they are Trump appointees, and yes, they are President Trump officials, but it is incumbent upon this body to do the oversight, regardless of who is at 1600 Pennsylvania Avenue. And Mr. Chairman, I just would encourage a yes vote to move this bill forward. I thank you for giving me the opportunity, and the gentleman from Pennsylvania and Ohio, I'm sure, have other things to share, but I yield back.
Thank you very much. Mr. Nadler, I'm delighted that you're here. Please be advised that I am in receipt of a letter of which evidently you authored, or at least co-signed, dated June 27th, and so I'd like to enter that. If you did not enter that into the record yet, I'd like to enter that into the record. I thank the gentleman. Yes, sir. Without objection, it'll be entered in the record. I'll make sure of that.
Mr. Chairman, the Rules Committee noticed this resolution as an emergency measure late last night. There are many emergencies facing the United States at this hour. The subject matter of this resolution is not among them. H.Res. 970 is wrong on the facts, wrong on the law, wrong on the rules, and a dangerous precedent to set for the House of Representatives. First, the resolution is riddled with inaccuracies. Taking this document at face value, you might think that the Department of Justice had not already sent us hundreds of thousands of documents, many of which the sponsors of this resolution delight in leaking to the public. The resolution also suggests that the Department has failed to substantially comply with subpoenas issued by the House Judiciary and Intelligence Committees. And the resolution relies heavily on the March 22nd subpoena issued by Chairman Goodlatte, a subpoena that was not issued in compliance with House rules and therefore cannot be enforced. Second, this resolution is premised on a demand for documents to which Congress is not entitled. To be clear, I firmly believe that when the House Judiciary Committee asks the executive branch for information, our committee is entitled to that information in almost every case. But we are not entitled to information that goes to the core of an ongoing criminal investigation. This prohibition is both a matter of constitutional law, it falls to the executive branch to enforce the law, and a matter of basic fairness. It is wrong to inject politics into criminal proceedings. I suspect that the sponsors of this resolution already know this. They are asking for documents they know they will probably never receive. And they likely view this impossible request as a win-win proposition. If they somehow bully the Department of Justice into turning over materials that go to the core of the Mueller investigation, that information could be shared with the subject of the investigation, namely President Trump. Based on past precedent, it would next be shared with anybody watching Fox News. Mr. Meadows said he recognizes the necessity to protect sources and methods. Yet already, the identity of a CIA agent has been outed. And if they do not pry these documents from the department, they will use that fact to further smear the special counsel, the Deputy Attorney General, and anyone else investigating the President. They have even suggested impeaching the Deputy Attorney General, a proposal that is both without historical precedent and patently ridiculous. Third, the manner in which this resolution has made its way to this committee is totally unacceptable. At yesterday's House Judiciary Committee markup, a markup that began an hour and a quarter late with no notice to the minority, Mr. Jordan offered an amendment to a Meadows resolution of inquiry. That amendment was clearly not germane. I raised the appropriate point of order. At that moment, Chairman Goodlatte exited the room. Representative Shabbat took the chairman's seat on the dais and agreed with our point of order. He ruled it out of order. Then the majority proceeded to overrule the ruling of their own chair, forcing the committee to adopt an amendment that was not germane and not entirely within our jurisdiction, no matter what you think of the measure on the merits. This move is without precedent. As a matter of practice, it was an entirely unnecessary show of disrespect to the rules of the House and to the institution as a whole. The majority can, of course, move any legislation it wants through the regular order at any time. Throughout this maneuver, our chairman stood in the hallway just outside of the hearing room, where he could watch the proceedings but not be seen by the cameras. He would not have participated at all in Mr. Jordan's drama had one of my colleagues not called out to him during the vote, at which time the chairman voted present, still standing off stage. Later, our members attempted to offer amendments to the Jordan text. We feel that any number of issues are more important than conspiracy theories about Hillary Clinton and James Comey. But when we attempted to add our concerns to this legislation, when we attempted to add amendments, the majority moved the previous question with 4 amendments still pending at the desk, cutting off even the opportunity to debate family separation, election security, and other obviously more pressing matters. And this was done after the minority stayed in an empty chamber for an hour and a quarter waiting for the committee to convene, and after about less than 2 hours. At that point, the majority felt the necessity of moving a motion on the previous question to deny the minority the opportunity to offer the 4 remaining amendments. Every Democratic member of the Judiciary Committee has just written to Chairman Goodlatte about this complete disregard for rules and process, and I thank the chairman for entering that letter into the record. What does the display at our markup tell us about this resolution, which is a close replica of yesterday's Jordan amendment? What does it mean that the leaders of the Republican conference seem unwilling to stand by this so-called emergency measure, at least not in public? I hope that it indicates at least some small measure of shame about resorting to these tactics. Finally, sending this resolution to the House floor tomorrow sets a dangerous precedent. If you do this, you will, in effect, have shown the American people that pure politics is more important than the facts, more important than the law, and more important than the rules that govern fairness and civility in the House of Representatives. And for what? You can force this fight with the leadership of the Department of Justice. You can demand documents that the Justice Department cannot give us and to which we are not entitled. You can attack the character of lifelong public servants like Deputy Attorney General Rosenstein and Special Counsel Mueller, both of whom I might add are Republicans. You can burn the bridges with your colleagues to send this resolution to the floor. But you cannot stop the special counsel's investigation. Before you vote today, I ask you, when the special counsel's work is complete, when the enormity of what he may have found has been laid bare, how will the American people judge you for your actions here today? I urge my colleagues to consider that and to oppose this reckless, dangerous measure. And I yield back.
Thank you very much. Does the gentleman from Pennsylvania wish to be recognized? The distinguished gentleman is recognized.
Thank you, Mr. Chairman. I am attending, and I'm privileged to be here. As you know, I was privileged to be on the Rules Committee as a state representative, and I certainly understand the overwhelming amount of work that the members on the Rules Committee put in just by virtue of the fact of the nature of that work. And so, as always, I am privileged to be here in support of this measure offered by the good gentleman from North Carolina and the good gentleman from Ohio. And as a person who does not have the privilege of sitting on oversight or judiciary or intelligence, but wanting to speak on behalf of all the members of this august body, and I mean the committee of the whole, who feel the same way, I just want to weigh in on their behalf. The framers of the Constitution designed this Congress to provide oversight over the executive branch, and that has served us well for over 200 years, Mr. Chairman. The Department of Justice simply must comply, and on too many occasions, having an open investigation and leaving it open has been a tactic to obfuscate and obscure from the public the truth of what's really going on and drag out the timeline. None of us here are saying that the special counsel's investigation should be closed prematurely. We want to see it come to finality, to its conclusion, to its correct conclusion, because we all want to know what the facts are. But we cannot allow that premise that it is ongoing to allow the Department of Justice to obscure the facts from the American people. Simply must comply, and Congress not only has a mandate, but each of us, in our oath that we took, have a duty. We have a duty for the American people to find out where this information is and what it is. And if we allow them to continue down this path, we will have not upheld our oath, and will have failed indeed in our oaths. And in doing so, we will have failed the American people in the process. We are smart, and I think it is right to remember that no one is above the law. No one. Not a politician, not political operatives, not political candidates. And I know that might draw the ire and some rolling of the eyes around here, and there's plenty of blame to go around in past administrations and current administrations about you should be investigating this and you should be investigating that. I'm not on any of those committees. I'm not on this committee, but this is the issue before us right now, and that's what I'm talking about. The rule of law is what makes our country strong, and it is the envy of the world. We're not a perfect country, but we strive for it every day, and so our Constitution says so. The truth is the truth, and it doesn't have an agenda. It's just the truth, and it should be laid bare. It should be laid bare for all to see. The American people deserve to know what their government is doing behind closed doors, and it is long past time. The fact that we even had to ask for a subpoena or issue a subpoena, Mr. Chairman, is ludicrous. And the fact that, some folks say, well, these are Republicans, and so, you shouldn't have oversight. Well, if they're Republicans and the books are all cooked, why wouldn't they just give us this information? This is not meant to impede an ongoing investigation. This is to sunlight what has been happening at the Department of Justice, and I have had, and I suspect that these members have had and other members have had, members of the Department of Justice and the FBI come into their office and contact them and say, keep going. Keep going. This thing is rotting from the top. And you must find out and preserve the fidelity of these organizations, these institutions, for the American people. They must have the faith and confidence to know that no one is above the law and that justice is equal and justice is blind. And the only way we're going to know that is when the truth comes out, and to ensure this transparency. And with that, Mr. Chairman, I urge adoption of this measure. I urge the colleagues to vote for it, and I yield the balance.
Mr. Perry, thank you very much. And I also want to extend my thanks to you for your service to the United States military. Little do you remember, but when you were a younger member, you and I spoke one day about your influence on young people who commit themselves to the protection of the United States of America, and you considered yourself an advocate for their learning. And I want to thank you for your service and mentorship to those young people. Chairman Jordan.
Thank you, Mr. Chairman. The ranking member from New York mentioned the word precedent. Here's the precedent that's being set. Right now, the executive branch is telling the legislative branch.
Does the gentleman wish to speak to the committee and then leave? I must. Well, then the gentleman would need to put a request in to me. Okay, I'll request your permission. If you'll please hold. Mr. McGovern, typically we try and talk ahead of time when we know we have something like this. Does the gentleman wish to offer any question to the distinguished gentleman before he leaves?
No, we believe in showing courtesy to members that we're not
I'm
showing.
I'm all for courtesy, but you and I both know that whether it's Republican or Democrat,
Committee. No, I know, but I think if the gentleman has to go, we will let him go.
Thank you very much. Gentleman may leave. Thank you. I'm sorry, but we do this out of courtesy to this committee, not and to you too. Thank you very much. Appreciate the distinguished gentleman's response. Chairman Jordan.
Precedent's being set. It's the executive branch telling the legislative branch, we're not gonna give you the information you are entitled to receive as a separate and equal branch of government to do your constitutional duty of oversight. Plain and simple. There have been numerous requests for documents that have not been complied with. There have been subpoenas issued by the Judiciary Committee, the Intelligence Committee that have not been complied with. We have caught the department trying to hide information from us, specifically text message between Mr. Strzok and Ms. Page where they attempted to hide the fact that Mr. Strzok had a relationship with had a friendship with one of the FISA court judges. Judge Contreras tried to hide that from us. Only reason they would do that is because it was embarrassing to the FBI or to the DOJ. Tried to hide that from us. Will not show us. Now think about this. Mr. Rosenstein writes a letter, or excuse me, a memo authorizing the special counsel on May 17th, 2017. He amends that, modifies that on August 2nd, will not show the Congress, will not show the American people how the parameters of an investigation into the President of the United States, how they've been modified, changed, or altered. And the last thing we know is it's been reported in the press that the Deputy Attorney General has threatened members, staff members on the House Intelligence Committee. That's the kind of treatment we're getting from the executive branch. And so all this resolution says is real simple. We want the weight of the full House of Representatives to go on record saying, just give us what we're entitled to have to do our job. It's really simple. Last thing I would add is this. Tell me if you've ever seen anything like this. The chairman's been here a few years, doing a great job representing the folks in Texas in his district. Tell me if you've ever seen this happen to any other federal agency. James Comey, fired. Deputy Attorney General or Deputy Director Andy McCabe fired, charged with lying 3 times under oath, faces a criminal referral. Jim Rubicki, Chief of Staff, has left the FBI. Jim Baker, former Chief Counsel at the FBI, demoted and then left the FBI. Lisa Page, FBI Counsel to Andy McCabe, demoted and then left the FBI. Peter Strzok, former Deputy Head of Counterintelligence, demoted, escorted out of the FBI just a few days ago. 6 of the key people who ran the 2 most important investigations in the last 2 years. The Clinton investigation, all 6 of those were involved. The Russia investigation, all 6 of them were involved. In fact, Peter Strzok was the lead agent on both investigations. Have you ever seen 6 of the key people where they've been fired, demoted, escorted out of the FBI? It's never, in my 10 years in Congress, I've never seen anything like that in any other federal agency. And all we're asking for is documents we're entitled to get, and they are giving us the finger. This is about the full House saying, going on record saying, give us what we deserve so we can get answers for the American people. Plain and simple. With that, I yield back.
Mr. Jordan, thank you very much. I'd like to advise the committee and our witnesses that we're on a vote with 0 time remaining. I'm sorry, I did not know we were that close. I'd like to ask that each of you please come back, allowing us an opportunity to engage you So subject to call, the chair will come back at the end of the last vote. Gave that to Jim. I was not trying to be a jerk. I was trying to make sure
Sound check for the court reporter, sound check.
Rules Committee, come back to order, and thank you very much for rejoining us. I know Mr. Nadler is going to plan to be here also. Thank you for the witnesses appearing today. Mr. Meadow, the conversation that you had with the committee is that you've made over 150 phone calls with the Department of Justice. They have partially provided information. They have not provided enough information. They have simply said they won't provide further information. Can you clarify what might be their position that, as you understand it?
Thank you, Mr. Chairman, and thank you for asking the clarifying question, because it's a little bit of all three of those. There have been a few items where they basically have said that they just will not respond. There have been a number where they've indicated that they've fully responded but haven't. And then probably the most troubling of all those are on the areas where they could respond, on the areas where there's actually documents to be provided. The pace at which they're responding is incredibly glacial. I mean, it moves at such a slow pace that, indeed, just the documents that we've currently identified would take over a year and a half to produce. At some point, you have to get to the point, and we've had multiple meetings. In fact, there was a meeting where we had DOJ officials in my office with Jim Jordan and myself there, where they said, we're going to get you the whole universe of the number of documents that are outstanding within 7 days. Well, that's been 3.5, 4 months ago, and we still don't know the number of documents that are actually even responsive. So to be specific, I think what is most troubling is that redactions continue to take place, material facts continue to be hidden and not produced, and ultimately the documents that we've requested are being met with a yawn when it comes from a DOJ's perspective. But it is a little bit of all three of those. Now, I know there's been press releases that the DOJ has put out that said that they've substantially complied. It's just not represented in the facts. And I'm speaking specifically to the thing that I know the best, which would be the request that we've made from OGR and the Judiciary Committees. It's just, a continual delay, and I probably have read more documents than most members, and I can tell you that the lack of transparency is deeply concerning.
One point, and perhaps just an observation.
Yes, sir.
Is this a bipartisan, both sides would receive the information? Republican and Democrats?
Without a doubt. In fact, on this particular issue, as if you take the DOJ, FBI, whether it's the mid-year exam, which is the Hillary Clinton investigation, or the Donald Trump investigation with regards to collusion accusations, I was probably one of the first members when we asked for a declassification of the Republican memo to ask for a declassification of the Democrat memo. I believe that this particular item, in terms of documents that are produced, should not have an R or D behind it, and so it would be available to both parties.
I thought it was most instructive that you indicated that they had agreed at some point to provide everything within a matter of weeks.
That's correct. Yes, sir.
I'm always struck by the government when they demand things from other people, that they demand them to be done rather immediately.
Yes, sir. Well, you're
And-
exactly right. The IRS would not give you the amount of time to comply with any kind of an audit request that the DOJ has had, and they're trying to comply with our request.
And I actually find that your methodology, your systematic evaluation of them has been met with calmness and professionality.
Thank you, Mr. Chairman.
And I think it would be fair for them to say, Mr. Meadows, we believe that that information, as the gentleman, Mr. Nadler, said, we consider this material to something that is so sensitive that we want you to know why we're going to provide a redacted copy to you.
Right.
But I do not consider it that they have not responded with other things which they had previously believed they could provide them within a relatively reasonable period of time. But I will go back on that same point. I think it's interesting that they demand things in investigations, meaning the government agencies, yet when the foot is on the other shoe, or the shoe would fit on the other foot as they would choose it to be, whether it's your foot or your shoe, they don't allow themselves, they don't put themselves in that same way.
Well, Mr. Chairman, you're right, and I think it is about that equal standard. Listen, if this had been the first request or the second request or the 10th request, perhaps this measure would not be required. But I can tell you that when executive branch agencies ignore valid subpoenas and valid requests, whether it's a Democrat or Republican request, it's inappropriate. It undermines the very nature of this institution to allow that to continue.
What's most interesting and instructive is it's an article against an article. It's one branch against the other.
Indeed.
And I think that it's most instructive to me, once again, that you have maintained, and Mr. Jordan and Mr. Goodlatte have maintained a professional atmosphere of accepting their delays, but not accepting their denial. I thank you very much. Distinguished gentleman from Georgia.
Thank you, Mr. Chairman. I very much appreciate what you all are doing. Nothing frustrates me more in this place than being feckless. But I'm confused as about order of laws. I don't serve on the Judiciary Committee. I don't serve on the Oversight Committee. I send you a valid subpoena and tell you to produce it, and you don't produce it. I send you another one and say, no, I really mean it, produce it, and you don't produce it. I say, no, this is really serious, and you don't produce it. Then I pass a House resolution that said, no, this time there's more of us who are serious, and you need to do it. Is there an order of, is there a process here that leads to different outcomes? I remember sending out our contempt notice to the Attorney General saying, I can't believe you're ignoring the Congress, and I'm going to insist on holding the Attorney General in contempt. And then the Attorney General decided he wasn't going to hold himself in contempt last administration. So help me to understand. I want to be supportive. I just don't want to add to my fecklessness. I want to mitigate it.
Well, the gentleman is exactly right, and I wish that I could give you a prognosis that will make you jump up and down and say that enough is really enough, and your point is well taken. Here's where I think that we will end up with this particular issue. Perhaps I've been ineffective in articulating how important this is. Perhaps the gentleman from Ohio, Mr. Jordan, has been ineffective in articulating how important it is. Perhaps the three chairmen have been ineffective in articulating how important it is, and perhaps the Speaker of the House has been ineffective in articulating. When you put the power of 750,000 people that you and I have the privilege of representing, 750,000 people in each congressional district that says, Deputy Attorney General Rod Rosenstein, we're not speaking just for Mr. Woodall or Mr. Meadows. We're speaking for the 750,000 people that we have the privilege of representing. Perhaps they will understand the serious nature of this, and at this point, it becomes critically important. We're going to have to ultimately decide whether to fish or cut bait, and a lot of times what we do is we just cut bait and we never fish. And at this point, I think today is the day that we need to start setting the line to let the executive branch know that we will not tolerate that. How much better is it to do it with a Republican majority, with a Republican administration? And hopefully that is the difference there. But the gentleman makes a good point.
Undeniably, that's true. It's easy to do oversight on the other guy. It's hard to do oversight on your guy. Right. And that, I think that does measure. My deepest concern is you raise it to the level, because I'm certain you have not been ineffective. I'm certain the gentleman from Ohio has not been ineffective. You raise it to this level of a date certain or else. We have an Article I obligation not to make empty threats. The expectation would be there is an or else, that else has a meaning in the world of oversight, in the world of judiciary, in the world of intelligence.
Yes, sir.
Am I correct to understand that there is an else, and that the Department of Justice would understand that there is an else that is coming?
I do believe that we've had a number of members, other than Mr. Jordan and myself, that have expressed the constitutional remedies that are available to us in this body. And I think that at this point, those or else would be the follow-up of that. Hopefully we don't get there. I'd rather get the documents than have the drama, as one of my colleagues said.
No, that is, Mr. Chairman, my biggest regret. It shouldn't have to rise to the level of the House passing a resolution to get production from your Justice Department. It ought to rise to the level of a committee chairman asking nicely to make that work. So I appreciate the work you gentlemen are doing. Gentleman from Ohio.
I was just going to add to my good friend, the gentleman from North Carolina. Just here's how bad it is. When we met with the Department of Justice several months ago, we asked them 4 simple questions. What's the universe of documents we're entitled to? Can you give us an approximate number? The answer was no. How does the process work now? How many layers does it have to go through before you can sign off on the document, get it to the Judiciary Committee, Oversight Committee, and Intelligence Committee? We don't know. How do you determine what gets redacted and what doesn't? How does that process work? We don't know. And then, of course, the fourth one, obviously they didn't know. When will we get what we're entitled to? We don't know. So that was the state of play just several months ago, and it frankly has not improved that much. So that's what we're dealing with. We feel the frustration every day because of the committee assignments we have, but it's important, I think, the full House know this, and like I say, go on record tomorrow.
Well, answering those questions, solving those problems is not going to accrue to your personal benefit. It's going to accrue to the benefit of this institution, no matter whether Republicans are running it or Democrats are running it, and the American people will be the ultimate beneficiaries. I thank the panel.
Yes, sir. The distinguished gentleman from Georgia
be happy to
controls
have the
time,
ranking.
and he's always very magnanimous in his opportunities to allow full
Thank you very much.
Ranking member.
All this rhetoric about Article I powers and Article II powers is very good, but it assumes good faith. There is not good faith. There is bad faith. There is an ongoing criminal investigation in the Department of Justice involving possible crimes that may or may not have been committed. Well, we certainly know crimes were committed. The Russians committed crimes in conspiring against our election. Whether people involved in President Trump's campaign committed the crimes of criminal conspiracy or other crimes or not, that we don't know yet. We will know yes or no, presumably at some point. There is an ongoing criminal investigation into the Russian attempt to interfere in our, not attempt, they did interfere, into the Russian interference in our election, and into whether Americans, and specifically people connected in one respect or another with the Trump campaign, joined in that conspiracy. This investigation is being undertaken by the Justice Department. Like any criminal investigation, there's certain things you cannot divulge to anybody else, even under subpoena. It is improper for Congress or for the House to subpoena certain documents related to an ongoing criminal investigation because it would sabotage that investigation. We know already of acts of sabotage. We know that Devin Nunes gave information to the White House. We've been told by Mayor Giuliani that information sought will be given to the president's lawyers for their use. That's wrong. At some point in a criminal investigation, if charges are going to be brought, then those charges are entitled to that information, but not prior to that. We have already seen an FBI informant outed because of leaks from this institution, because of these demands, and the demands that have been made, not all of them, some of them may be valid requests, but some of them to request, for instance, this precise scope of the charging documents to Mueller, highly improper. Would give potential defendants a roadmap, and that's not what you do. Now, eventually, if charges are going to be brought, they will be entitled to that information, but not now. And nobody will doubt that if that information were given to committees of this House, it would be on Fox News the next day and in the hands of of Mr. Giuliani and others, either the day after or the day before, depending on the relative standing of Fox News these days. So the Justice Department cannot comply. Now, the second problem is, with some of the requests, the second problem is they've been requested to hand over they've handed over, we are informed, hundreds of thousands of documents. There's a finite amount of manpower and womanpower available, and you tie them up totally so they can't carry on the investigation. And during this entire period, there is a concerted campaign going on by the White House, by members of this House, by others, to sabotage the investigation, to convince people of its lack of integrity. The president tweets all kinds of terrible things. I don't have to repeat them here. It's a witch hunt, et cetera, et cetera. And the fact is, we don't know what they're doing. This investigation is, well, the whole debate is one-sided, because you have members of the House and the president and others yelling it's a witch hunt, it's terrible, there are 13 angry Democrats, they're doing terrible things, et cetera, et cetera. What do we hear from the investigation? Nothing, because it is improper to leak. It is improper for Mueller to get up and say, it's not a witch hunt, I'm doing this, I'm doing that, I'm doing things properly. He doesn't say that, nor does anybody connect with the investigation. What do we know about what's going on in the investigation? What do we really know about the investigation? Only a few things. We know that certain people have been indicted, and we know what the indictments charge, because they were filed in court. We know that certain people have pleaded guilty to various crimes, and we know the details of that because they're filed in court. We know that certain subpoenas have been issued because they're public documents in court. That's all we know. Whether the investigation is being done honestly, which one would presume from the integrity of Mr. Mueller and the others, wholly declaimed by Senator Hatch and all the Republicans at the time that he was appointed. What a wonderful guy he is. Everybody said. One would assume that. But whether it's the integrity is going fine or whether it's dishonest or anything else remains to be seen when they issue their report or whatever happens. But instead, there is a concerted effort to defame them, to defame the administration, and in effect, as Mayor Giuliani said, since the president cannot be indicted, at least that's the opinion of the OLC and apparently of Mr. Mueller, since a president cannot be indicted, as a matter of law, I don't mean this particular president, but since a president cannot be indicted, assuming that the investigation were to conclude that the president committed crimes, all they could do would be to issue a report. They could not indict him, they would issue a report. Okay, and if they conceded that he didn't commit crimes, they would presumably say that too. But the worst case scenario is they could issue a report saying bad things about the president and maybe indicting other people. And the jury pool, in effect, is the public and the Congress, because maybe that leads to some people saying there ought to be an impeachment, maybe there shouldn't. And Mayor Giuliani admitted what's going on. We're winning the battle for public opinion. In effect, he's saying we're poisoning the jury pool by defaming the investigation. These requests, I believe, are part of that campaign of defamation. They're in bad faith because they are asking, how do we know that? Because they're asking for things that ought to be granted, and have been in large numbers, but they're also asking for things that, as a matter of law, cannot be granted.
And if the gentleman may be
Yes.
able to clarify for me, does that mean that these requests have been responded to with a notice that says, as a matter of law, Congress, I cannot produce?
Would you yield?
Be happy to yield, my friend.
I'm confused. Was the request made to special counsel?
No, no, no.
This has
No, to the
nothing
Department
to
of
do
Justice.
with, this has nothing to do with the special counsel.
Oh, but it does.
And
And it does for the following reason.
Well, you're answering my question. The request was to the Department of Justice, and then I said, what does that have to do with special counsel?
And the answer is, among the requests were many documents with respect to the charging documents as to the scope, what the special counsel may do, what his authorization is from the DOJ. That request was made of the DOJ.
Is that not public record?
No. And if it's amended, it shouldn't be, because that would give a roadmap to the investigation to possible defendants.
Well, I know
For
it's the
example.
gentleman's time, but I believe what today's hearing is about the conduct of the Department of Justice, not related to this, and I'm a little bit surprised to see, this is about the special prosecutor. I think it was about the conduct of the Department of Justice, the FBI, and any federal agents as it related to before what I presumed was this election.
Well,
Thank you very much.
Very welcome, Mr. Chairman. The gentleman from New York is sincere, I believe, in his belief that there's a concerted effort to defame, but I am absolutely certain that I am not a part of that effort.
I didn't say you were.
Of course not. A gentleman's sincere in his belief there's a concerted effort to obstruct. I know that I am not a part of that effort, a concerted effort to undermine. I know I am not a part of that effort. I do have a sincere concern that both parties in Congress have shifted power to both parties in the White House over a long period of time, and that we have fewer tools in our toolbox today because we have used them so ineffectively over the...
I agree with you.
So stipulating to...
I agree with you.
I thank the gentleman. Knowing of your very real concerns about which subpoenas ought to be issued and which should not, which documents ought to be requested, which should not, recognizing there may be a grain or more truth to any of those concerns, is there also a grain or more truth that there are documents within the Justice Department today that we as the Article I branch, you believe we absolutely have a right to view and that the Department of Justice is absolutely obstructing our Article I prerogative?
Well, that's two questions. To question number one, yes, obviously there are documents we have an absolute right to see. Question two, have they withheld it? That I don't know. My counsel may know that. I don't know that. Okay.
Well, I know that we are stronger in dealing with Article II when we stand together as Article I. I regret if this is not the time we're going to be able to do that. I know the two gentlemen who are testifying to your left. I say to the gentleman from New York, and I.
To my right, they would want to be there too.
To my left, you're absolutely. We would not have arranged the table any other way. And I know them to be sincere and passionate, and I regret that oftentimes passion and duplicity look very similar in this institution. I have seen it on more than one occasion. I've seen my colleagues act in ways that I find because of our personal relationship, Allison, because I know that if I were to wrong you, that is probably exactly why that is. I say to the gentleman from Florida. These issues are so important. I believe the House cannot afford to be divided on them, that unity in dealing with a White House, which will always be so strong and powerful, is our best tool to control it. And I would say that we are, in fact, charged with controlling that White House. I thank the gentleman from North Carolina.
If I could just, I know the gentleman to my left did not mean to impugn the reputation of any member by suggesting that their motives were not pure. I think he was talking about maybe in totality about motives that were not pure. I can assure the gentleman.
I'll agree with that.
And the other thing is, when we talk about leaks, there is no doubt that this institution does leak, but I want to make sure for the record that on this particular issue, while I can't talk to the number of leaks coming from DOJ, I can tell you that there are leaks coming from the DOJ and FBI as it relates to these matters. And those leaks specifically have gotten to the New York Times. I've learned things that I did not know, so we weren't capable of leaking it because it was knowledge that only the DOJ and FBI had. And I've confronted them about it. And so when my good friend, and I mean that in a sincere way, mentions about leaks, we must, for the record, understand that the DOJ and FBI continue to use the media at times to their advantage, and I just want to clarify that. Thank you.
Well, I thank the gentleman for the clarification, and I would tell the gentleman I would be as enthusiastic about using our powers to quash and punish those leakers as I would about demanding those documents. I would hope we could all agree in a bipartisan way that to do our job up here, it has to be done in a way that members can trust one another, and if we are a part of that leaking process, we should be dealt with accordingly.
Well said.
I yield back to the chairwoman.
Gentleman yields back. The ranking member, Mr. McGovern.
Well, thank you, and I'll try to be brief because the fix is already in, and we know how this is going to turn out here in the Rules Committee. But I do want to begin by saying, pointing out that everybody got to speak. Nobody was interrupted. Nobody here was cut off prematurely, which is kind of a contrast to what I understand happened in the Judiciary Committee. And I just think that's worth pointing out. Especially on an issue like this, if we're talking, as Mr. Woodall says, that we need to come together, I think we need to avoid repeat performances like occurred in the Judiciary Committee. And Mr. Woodall says, oh, he regrets that we're at this point where we have to have this resolution. And I'm just looking at a Politico article from today. Today's June 27th. Says House Speaker Paul Ryan, House Judiciary Committee Chairman Bob Goodlatte, House Oversight Committee Chairman Trey Gowdy, and House Intelligence Committee Devin Nunes huddled with Rosenstein and other Justice Department officials last week to review outstanding document requests, and Ryan emerged from the meeting suggesting that progress has been made and that the extra time the FBI requested for additional documents was, quote, reasonable, end quote. So that's the Speaker of the House. You might want to, yeah, I'm happy.
Yeah, I mean, I'd be glad to address that. There have been a number of conversations with the Speaker. I think that particular article pertained to one aspect, but there was two other deadlines that came up. One that was last Friday, the other that was Monday, and then the other that was actually at noon today. And they were notified that those the documents that were to be made available weren't made available, and so that may be.
Yeah, I just found that curious.
Right, but I just wanted to clarify it because and speak to the gentleman's question.
Right. I'm reading the resolution. Just I'll read one couple sentences from it. It says, whereas the power of the Congress to conduct investigations is inherent in the legislative process, that power is broad. It encompasses inquiries concerning the administration of existing laws, as well as proposed or possibly needed statutes, and comprehends probes into departments of the federal government to expose corruption, inefficiency, or waste. And I guess I'm just wondering, where is the oversight of some of the things I mentioned to begin with? I mean, Administrator Pruitt's like living lifestyles of the rich and famous at EPA. I mean, clearly, by all accounts, is I think abusing his position and spending $43,000 on installing a soundproof booth in his office. I mean, we have scandals involving private planes. We have questions about whether the administration is in violation of the Emoluments Clause. All these conflicts of interest with the president's families and money-making ventures that are going on, and I'm just wondering, where the oversight is on that, and maybe you can enlighten me how many subpoenas have been issued under Chairman Gowdy to kind of look into any of these things.
The gentleman's question is certainly spot on, and as I mentioned earlier, I've actually teamed up with some of my Democrat colleagues to make sure those documents are made available. Interestingly enough, those requests for documents actually are being supplied as we've requested those through OGR. We've had a number of those documents not only reach us. In addition, when there was a critical issue as it related to the census, something that a number of my Democrat colleagues expressed concern. Again, at that particular point, we felt like it was important for this institution to make sure that witnesses showed up. So not only did we have a hearing, we had a briefing, and then we subpoenaed the witness from DOJ who would not come in, because we felt like it was critically important to do that. And I can just tell you that a number of those issues, as you've enumerated those, we're receiving documents and doing real oversight into.
Well, there must be unbelievable cooperation, because from what I understand is that under President Trump's tenure, Chairman Gowdy has not issued a single subpoena. Zero as chairman of the Oversight Committee.
Generally speaking, that's what makes this so unique, in that generally with a Republican majority and a Republican administration, the flow of those documents happen a little bit.
Because by contrast,
and that's what makes this.
Yeah.
Well, but that's what makes this so unique, in that we have a DOJ that's essentially defying the transparency that should be there.
Well, the way it looks to me is that this is not an example of Congress standing up to the executive branch or to the White House. I mean, because quite frankly, I think what you're trying to do, I think, is to provide cover to the White House on a very serious matter. I mean, I got to tell you, you say you represent 750. We all do, 750,000 constituents. And my constituents used to be, people would ask, who in the Trump administration met with Russian contacts. Now the question is, who in the Trump administration didn't meet with a Russian contact? And not only that, and what's particularly alarming is the fact that everybody has amnesia about it. It isn't until later on, after they deny they've had any contacts, that we learned that they did, and oh, I forgot. So there's, I don't know how this investigation ends up, but I will tell you, the fact that Russia attacked this country by interfering in our election, the fact that there is certainly lots of smoke, to put it mildly, that there were contacts between the Russians and operatives in this campaign, I think should compel every one of us to want to get to the bottom of this and to figure out what happened.
I couldn't agree more. That's why we need the documents.
Yeah, well, yeah, but I guess I sense that. So
you would rather me make a decision without the
No,
documents?
but I go back. No, I want you to get all the documents that you're entitled to, but I don't want you to basically screw up an investigation that I think is a legitimate investigation. And as Mr. Nadler pointed out, given the sensitivity of this investigation, yeah, you ought to be able to get what you need, but there's some things that, because of the nature of this investigation, you shouldn't. Mr. Nadler, you talked about a CIA operative, cover being blown. Can you just, for the record, state what that is?
This was a CIA informant,
right,
who spoke to, this is widely reported in the press. I'm just saying from memory what I've heard in the press at this point. Talked to, I think it was Papadopoulos and maybe Carter Page, 3 different people involved, and reported to the FBI that, about Russian contacts with people in the Trump campaign. I think this is one of the earliest indications. This fellow turns out to be, I think, a British professor. I'm not going to mention his name, although I could. It's been in the Washington Post, et cetera. And his name, his identity was outed through congressional action, through members of Congress. I don't remember which ones, and I wouldn't mention if I did, but it's all a matter of public record. And that's highly destructive.
I would disagree with 2 fundamental things. I don't know that was outed by any member of Congress. One, I didn't know if those reports are true, but I'm learning something here today is the gentleman saying that the person worked for the CIA. Well, I've got a concern if
he was an informant. I don't know if he worked.
If you've got CIA working with the FBI to surveil American citizens, that's troubling.
I know the CIA.
Yeah. Well, look, I mean, like I said, I mean, the process to get us here in Judiciary Committee, I have to tell you, if the shoes were on a different foot, you'd be up here screaming. And I guess that's the way this place is being run these days, but it's not, I don't think it reflects well on this body. And I mean, the fix is in. This will be a closed rule. You'll get it. We'll deal with it tomorrow. But it's a very disappointing way we're moving forward here, and I yield back my time.
The gentleman yields back. I'm new here, but it strikes me that as an institution, every single member of this body, regardless of party, ought to be very concerned about the prerogatives of this institution and ought to be very concerned about making sure that there is a response, no matter what party is in charge in the Oval Office or at the Justice Department. And I can tell you that for my constituents, as complicated as this all can sound, the thing that really hits home, and again, to me, this should be a bipartisan issue, is the notion that the President or the FBI or the Department of Justice in the previous administration used a political document, submitted a political document, paid for by a political campaign to the FISA court to obtain a warrant to conduct surveillance on an American citizen. When we've gone down that path, there's, in my view, nothing that can justify a situation now where a Congress is investigating that, and the executive branch, again, regardless of party, the executive branch is basically stiffing us. So I appreciate very much.
The gentlelady would yield for just 1 second.
I'll yield to Mr. Nadler.
Thank you.
Mr. Nadler, can you yield to me when you're done?
Yes, I suppose if I can.
I'm not sure.
I want to make 2 comments. One a more general one, and then one specifically to what you just said. It is very important that the Congress safeguard its powers, especially with regard to the executive branch. And what I'm about to say has nothing to do with partisan politics or the identity of a president. We have permitted, over the last, since World War II, we've permitted our war-making power to go largely to the executive. That's wrong. I was astonished in the last few weeks to learn that I didn't know that the president could unilaterally, by declaring national, what was it, by 232, impose tariffs. I learned American history. I remember the Tariff of Abominations of 1828. I remember the Huth-Smalley, always congressional. The power to impose tariffs is a tax. The power to impose taxes are a fundamental prerogative of Congress. We apparently, in Section 232 of the National Something or Other Act, Security Act of 1950-something, at the height of the Cold War, gave the executive the power to impose a tariff for national security purposes. I hope they meant that fairly narrowly at the time, but clearly now you're making major economic decisions. The legal fiction that Canada is a national security threat, we ought to have, but clearly we're making major tariff decisions. Those should be congressional. Those are examples of, yes, we should be we should recover. I sometimes feel like, what was it, Edmund Burke resolved the power of the Crown has increased, is increasing, and ought to be diminished. In 1790, we ought to repeat that. Coming to your more specific, and I've read the documents. But I'm not going to say anything. I hope I'm not going to say anything that I shouldn't say. But the fact is, there's nothing wrong with quoting a document in a FISA application, along with many other documents, and it was a voluminous application, and there were many. You have to get a FISA warrant, you have to convince the judges there's probable cause to believe a crime was committed, or an intelligence.
But reclaiming my time, Mr. Nadler, isn't it the case, however, that you have an obligation when you're submitting those documents to the FISA court to make sure that the court to which you're submitting those documents understands the source of the documents?
Yes.
You have an obligation.
Yes, and
the documents that have been declassified, which are the only ones that I've seen, make clear that that actually did not happen.
The court was informed that the documents were, I have to be careful what I say here. The court was informed that the documents were paid for by a biased source, and the court therefore had the ability, knowing that, to weigh that fact, and period. And they had many, and there were many other documents and sources for that for that warrant. And there's nothing wrong with submitting a source paid for by a biased source, as long as you tell the court that.
Yeah, but with all due respect, Mr. Nadler, and I think this also shows why we need to get these documents, frankly, because we need to see what's in them. But the bottom line is, when you're conducting surveillance on an American citizen connected with one of our presidential campaigns, and the incumbent in office is in a position where officials for that incumbent are securing the warrant based on a document paid for by the opposing political campaign, that should raise concerns among every American, regardless of party. And I think it goes to why we need this resolution and why we need these documents.
But that's why, with all due respect, that's why you have the court to make that decision. The court decides whether they were properly, well, they were told that it is a biased document, not that it's a biased document. They are told that it was financed by a biased source, They are told, they know, they can judge how to weigh it, they have that information, and they have many other things it's only one of the things for the FISA document, and the court makes that decision.
Mr. Jordan?
The chair is exactly right. We've all seen the footnote where they were supposed to tell who the source was who paid for the dossier, but the fact is they led with it. They didn't fully explain who paid for it, and more importantly, they didn't tell the court the guy who wrote the darn thing had been fired by the FBI. So when you or I go to court, we're supposed to tell the truth, the whole truth, nothing but the truth, and the stinking top people at the FBI who put together the FISA application should have to do the same darn thing, and they didn't. And they didn't just do it once, but they probably did it 4 times.
And again, I think this just goes to the notion that Congress has a crucial oversight role to play here. We shouldn't be making any assumptions. Based on what we have seen, I think there are serious constitutional concerns that are raised, and I applaud very much the resolution that we're bringing this.
I will, if I could reply to that. Number one, the appropriate people on the appropriate committees have seen that. I mean, well, it's classified. Whether you have a problem with the classification within Congress is another question.
Mr. Nadler, but I need to reclaim my time. I appreciate your views, but I think, again, you and I can have this argument. It's not very fruitful when what we do know, in fact, is that they have not produced the documents, have not explained why they haven't produced the documents, and deadline after deadline has passed.
I don't think
if the executive branch is not going to be responsive to a subpoena, we have an obligation that we take the next steps here. And let me now...
You just briefly?
Promise?
I promise briefly. I just want to, I mean, look, as we said, we know the fix is in here. I mean, we know what's going to happen in this committee, and we know what's going on the floor tomorrow. But I do find it a little bit, I do find it a little bit ironic.
No, but reclaiming my time. The fix is in when a Republican majority in the House of Representatives is trying to basically pass a resolution that will require a Republican executive branch to turn over documents.
No,
it's hard
to protect the Republican president, But the fix is in when in a Judiciary Committee, Democrats are shut off. The fix is in when we are routinely cut out of the amendment process time and time again. So that's where the fix is in here. We all know that. But the point I was just trying to make is one that Mr. Nadler made. You know, everybody's talking about here, that we got to reclaim our rightful power as the legislative branch, when in fact, ironically, just yesterday in this committee, once again, the Republican majority refused to allow us to have a debate on an AUMF. I mean, if you read the Constitution, we have a responsibility when it comes to war making, and this committee in particular, time and time again prevents us from doing that. So if people are really concerned about reclaiming our legitimate powers as a legislative branch, maybe you ought to begin with that, and I thank the gentlelady for yielding.
The gentleman yields back. Does the Vice Chairman, Mr. Cole, have any questions?
I have none. I appreciate the gentleman being here. Appreciate their efforts very much. Yield back.
Gentleman yields back. Judge Hastings.
Thank you very much, Madam Chair. Mr. Nadler, is the ongoing investigation, to your knowledge, a criminal investigation?
Certainly.
Mm-hmm. And you indicated earlier that a number of documents have already been provided, and then Mr. Meadows spoke to there being 1,400 of thousands of documents, and he indicated that there were only 1,400 that have been provided. What is your understanding of the number?
I don't have that information. I don't know. My staff has it. I can get it, but I don't know offhand.
Is it, to your knowledge, more than 1,400?
I don't know.
Perhaps Mr. Meadows can help me. Is it more than 1,400 that have been provided?
There's only 1,400 documents that have been provided for item number 7 of the subpoena. There are 22,195 documents on item 1. There are 0 on item 9. And so I know these numbers like the back of my hand. Out of 1.2 million documents, we have now had a little over 24,000 documents provided.
All right. Is this?
And one other, Judge, one other point. I'm not sure it's a criminal investigation. It started as a counterintelligence investigation with the special counsel. They may make criminal referrals, but it's a counterintelligence investigation unless something has changed.
Now, you're talking about.
I would point out they've issued criminal indictments.
You're talking about the Mueller investigation?
Yes, sir. It's a
the same investigation that the chairman said
that was what he was speaking to, and I'm just saying that I think it's a counterintelligence investigation.
If it ain't a criminal investigation, it sure has wound up with a whole lot of people being charged with crime. But the rest of it may very well remain to be seen. But is this document that we're dealing with, I came in here and I had amendment to the amendment in the nature of a substitute. And then I was sitting here for a protracted period of time before I even realized that I didn't have this document. Is the one we're discussing today your so-called resolution, which I question the nomenclature, but is this the same document that you all had the kerfuffle yesterday in the judiciary?
No, similar, but not the same.
Has this one been recorded with the clerk?
The amendment I offered yesterday to Mr. Meadows, he had 2 resolutions that was introduced 2 weeks ago. I offered one resolution amending it into the other. That amendment is not the same as the resolution that the rules is in front of this committee at this moment. Very similar on the document side, but there are things that were removed from the amendment I offered yesterday that are not in the resolution we are dealing with.
Okay, so then my question is, did you all go through your Judiciary Committee rules with this particular document that we're discussing today?
No. Well, no. It was a different document yesterday. Yeah. It was a larger document yesterday with more items that we were requesting from Department of Justice. The resolution in front of this committee at this time is a smaller document, not requesting as much.
Mr. Jordan and Mr. Meadows, I'm not unmindful of the wing of your party that you represent. And in some respects, have differences with our Speaker of the House, yours and mine. Speaker Ryan is on record saying that he reviewed documents and felt the request for additional time by the Justice Department was reasonable. Have you all discussed this matter with Speaker Ryan, and what is your disagreement with him, with he having reviewed the documents?
We've had several discussions with Speaker Ryan and other members, and the Speaker's office drafted the resolution that is in front of the Rules Committee today.
And notwithstanding, you don't feel that it was reasonable time for the Justice Department to answer?
Yeah, I think obviously we don't feel like it's been reasonable, but
you use 98 days, right,
but
Mr. Meadows?
I'm not at odds with the Speaker on this particular issue. When that published report that I believe you're referring to indicated, there were certain additional timelines that the Speaker laid out that have now expired and still no compliance.
Yeah, well, I'm a little concerned about the validity of your subpoena, but I guess we'll leave that for another time. Mr. Nadler, let me give you a nickel's worth of legal advice. And in the future, unless necessary, and I don't mean this in any harsh sense, try not to talk about, you were very careful and very cautious about the FISA ongoing circumstances, but if I were you, I'd leave that alone. And I want to tell all of y'all something. Have any of you been judges before? Well, I have. And I can tell you this much, that I also was on the Intel committee at the time that the FISA courts came into existence. And there was a whole lot of thought that went into it. And the selection process was one. And I happen to know some of the judges that have served on the FISA court. And I want to let you know that they're some of the finest members of the judiciary in this country. And all of what you all may perceive as something that was put over on the FISA court, I can tell you the FISA court and any judge has a way of dealing with matters when they were not presented to them truthfully. I have shepherded some warrants in my lifetime. Now, Mr. Meadows, you used the term that it's been 98 days since the issuance of the request. Is that correct?
I would have to check my calendar to make sure it's at least 98 days or more. The subpoena was offered on March the 22nd.
And you don't think that an investigation of this magnitude is deserving of the time that authorities feel is necessary before providing information that may be classified?
Well, I can tell you that the subpoena that went in on March 22nd, Judge, was not the first request. It was actually, the first request was on November 3rd of 2017. Mm-hmm. And so when you look at the items that we're requesting and the number of people at FBI that are working on them, there's 54 people now supposedly working on them. You know, they produce the average of about 2 documents a day with 54 people. You and I wouldn't get paid for working in that manner and producing that number of documents, and I think we would both believe that to not be efficient.
Have any of the 3 of you served on the Intelligence Committee?
I have not.
I have not.
Mm-hmm.
The documents we're requesting are not necessarily just subject to the Intel Committee's oversight. They're judiciary and oversight requests.
All right. That was the point that I wanted to make, that it was sort of like a combination of matters. Let me get very personal with you all about investigations. I'm the only person on this dais that has been investigated, indicted, impeached, and removed from office. That took 8.5 years of my life. And at no time did I feel that the authorities exercising their prerogatives, be they Congress or the FBI or the Justice Department, were utilizing their time in a manner that was not pertinent to what they felt were their investigatory responsibilities. It was distressing, but I don't see your fit of pique, and that's what I refer to it as, regarding the authorities as being all that unreasonable. I'm in this same body with you all that have conducted ongoing investigations. The most classic one would be Benghazi, that went way beyond where we are right now. And I just find it passing strange that we find ourselves in this position that we're in. Mr. Jordan, you're a lawyer. You're not? God bless you. You're an economist? I see. And that's why you like wrestling with these kinds of undertakings, I gather. I thought that you were a lawyer. I know Mr. Nadler is, and I believe that Mr. Meadows is, before in his other life, becoming here a business person. I ask that for the reason that on this Rules Committee is a friend of mine and is a former prosecutor. That's my friend from Colorado. And I would be particularly interested when he gets his turn that he not respond to me, but just point out that when the authorities are conducting investigations, it's not a good thing for Congress to make up its mind to involve itself in the investigation. And to a relative degree, that's what you are doing, and Mr. Nadler has pointedly cited to the fact that some of what you are seeking could very well alert persons who are being investigated in a manner that's inappropriate. I don't know where the leaks that all of us have seen came from, but I do know many of the protocols of the intel side of this would certainly disallow classified information being made public. And when I was on the intel committee, what we made sure of, and I might add, I interacted at different times, not on any criminal investigation, but with FBI Director Mueller. And so let me just put in a word for him. I don't know Mr. Rosenstein, but I can have you all assured that if there's something deserving of being addressed, then there is no more straight arrow that I have met in the FBI than Robert Mueller. And I believe when he concludes his investigation, that whatever he says is going to be validated. And if there's there, he'll say it. And if there is no there, he'll say it. And I believe it will satisfy most of us. Now let me follow on with what Mr. McGovern was trying to get across to you in part. We haven't had any oversight hearings on prescription drug prices. We're going through all of this stuff with reference to immigration and the gross negligence, in my judgment, of the Homeland Security and the Department of Justice certainly deserve full oversight by Congress, and yet we have none. Mr. McGovern spent some time on the Pruitt stuff that's going on. No oversight, although there are in excess of 10, probably as many as 12 or 13 IG and or other investigations going on. The president has been in the business of pardoning people and talking about pardoning himself. And it's unsurprisingly, the White House has ignored Democratic requests for more information on how the administration views pardon power. And the chairman of your Judiciary Committee has ignored multiple requests for a hearing on this topic. Something that I believe everybody in this room understands, that anybody that ran for president in modern times provided the public with his taxes. And yet, at least 8 times, this Congress's Democrats have attempted to bring bipartisan legislation to the floor requiring the president and candidates for the presidency to disclose their tax returns, but my friends have blocked our efforts every time. Mr. Meadows, you mentioned the census. I'm glad to hear your concerns, but I want you to know we still, while looking into the issue, have not had what I perceive as critically important hearings in that regard. Perhaps I'll leave the president's emoluments and business dealings on the side because certainly the Judiciary and Oversight Committee have refused to hold any hearings related to these emolument clause violations or to investigate their abuses. And I'll end with this. Mr. Jordan, you did a riff on the number of people in the Justice Department that have left, forced out, walked out, or escorted out. I guess one or two of them maybe resigned. Well, let me give you, in your remarks, what you said was that you haven't seen anything in any governmental agency the likes of what has happened in the Justice Department. And had you just restricted it to the Justice Department and not talked about the possibility of other agencies being looked at, Michael Flynn resigned from office, Rex Tillerson was fired, Hope Hicks resigned, David Shulkin was fired, H.R. McMaster was fired, Gary Cohn resigned, David Sorensen resigned and or was forced out, Rob Porter resigned or forced out, Omarosa Newman was escorted out, similar to Trotch or whatever the gentleman's name. Tom Price, former colleague of ours, good friend of mine, resigned or was forced out. Sebastian Gorka, in my judgment, should have not been there before he resigned or was forced out. Steve Bannon was forced out. Anthony Scaramucci was fired. Reince Priebus was forced out. Sean Spicer resigned. And I have an article here, and I ask unanimous consent, Mr. Chairman, to include it in the record, that talks about all the people in this agency that have either been forced out or resigned. And I'll call you and match you one more on agencies where people have left their positions in the most critical position in this country, and that is as the executive of this administration. But let me tell you what's even worse. Not the people that have left, but the people that haven't been hired. And the State Department would be a good example of that, where there are vacancies that need to be filled, and we aren't doing any oversight about that. I yield back my time.
The distinguished gentleman from Louisville, Texas, Dr. Michael Burgess.
Thank you. Thank you, Mr. Chairman. And I'm not a lawyer. I'm just a simple country doctor. So this has been a little hard for me to follow. But did I understand correctly that this began as a resolution of inquiry in your committee?
Yes.
And was that offered by you, Mr. Jordan?
It was originally offered by Chairman Mr. Meadows, introduced 2 weeks ago, along with the Sense of Congress resolution. The resolution of inquiry was brought up to the committee, and I offered the Sense of Congress resolution as an amendment to that.
So generally, a resolution of inquiry, I mean, I've had some experience with that, but I remember it from the time when we were in the minority, and it generally is a tool of the minority when the administration and the majority party in the Congress is not helpful. So do I remember that correctly?
Privilege, you're right.
I got a lot of use out of the resolution of inquiry when the Affordable Care Act was in Genesis. So I do remember the classified memos that we declassified and made available to members of Congress. I remember some discussion around that time about the application for the FISA warrant. Judge Hastings has advised us not to talk about the FISA warrant, but I seem to recall that was pretty important at the time. Did you all ever get what you were asking for with the information about the application for the FISA warrant?
No, Doctor, we have not, and much of the correspondence as it relates to that we believe is significant in terms of our proper investigative oversight role.
And it just seemed to me that went, of course, right to what Representative Cheney was talking about, and you had the party of an opposing political power actually seeming to use the office to put the thumb on the scale against someone who was seeking office. I got to tell you, I mean, and some of this is hard to follow, and I sympathize with my constituents who are frustrated that it was July of 2016 when all this stuff started.
Right.
And it doesn't seem any closer to resolution, and it seems endless. There are days where it seems like some of the players in this drama, I'm not talking about in the congressional committees, but just the people whose names you see paraded before the nightly news. I mean, it almost reads like something that Franz Kafka would have written. I mean, the guilty assumption was made, and now we're going to find the crime to fit our narrative. At least that's the way it looks to me as someone who's uneducated in the law and just as perhaps a little more than a casual observer. I appreciate what you all are doing. I think people need to get answers here. I'm frustrated that it's taken so long. And I think the blame for that lies on both sides, but I appreciate your efforts in trying to get us a conclusion here.
I think they're good.
Thank you, Mr. Chairman. I'll yield back.
Gentleman yields back his time. Thank you very much. The distinguished gentleman from Colorado. No question. Gentleman does not seek time. Ms. Torres?
Just a couple of questions. Regarding the time period when this whole investigation started, I believe it was July of 2016. During that time, there was also a call out, a cry out from then candidate Trump to Russia to release whatever information that they had to his campaign or to the general public. Just want to clarify that for the record. Is there, Mr. Meadows, is there a precedent to demand documents which could infringe on the compromise of this ongoing investigation?
Certainly, the role of the legislative branch being different than the executive branch, one is not mutually exclusive of the other. I might point out to the gentlewoman that the special prosecutor's investigation is a unique investigation. It's an independent investigation. The documents we're requesting are actually from the investigation that was prior to that. And so while they may be tangentially related, it is not part of an ongoing investigation, although documents certainly may have been referred. But this is all part of an investigation that was being conducted by the FBI and DOJ leading up to the 2016 elections. Once the special counsel was appointed, that became a new independent investigation, and as I recall, it would be a counterintelligence investigation.
So in short, the answer to my question is no. There's no precedent.
Well, I think there's plenty of precedent in terms of getting other documents. Is your question, was there precedents where we have requested
where
documents during
documents
an ongoing?
that
yes,
could
I mean, it's happened all the time.
compromise.
It's happened numerous times before where we've had that. We've requested documents during the Fast and Furious investigation.
Well, even when there was a special counsel back Iran-Contra, the Congress was still conducting their oversight and doing an investigation. So that in and of itself doesn't prohibit us from doing our constitutional duty, which is exactly what Mr. Meadows and I are seeking to do with this resolution, is get that information so we can do that.
So moving forward, there is no penalty in the legislation for the Department of Justice for not complying with this legislation. So if the department does not give you what you are demanding, what measures are you considering?
I think the only documents, and I think the gentleman, Mr. Woodall from Georgia, mentioned what other remedies might be out there. We certainly have constitutional remedies that this body could employ, which would certainly be censure, contempt, impeachment. Those are other constitutional authorities that this body holds.
Does it include what the president ultimately wants, is to fire the special counsel?
Actually, that is not part of this resolution, and certainly not part of what is contemplated. But the special counsel with this authority, I don't know that we have the authority to do that.
So considering the potentially sensitive information that could be in the DOJ documents that you are requesting, what assurances are there that when you do get these documents, that they're not going to be shared with people from the outside, or that someone from the committee is going to run over to the White House and say, here, President Trump, this is what we got for you, and you treat, and it's not even Halloween?
Well, certainly, I don't know about holidays and where they may or may not be, but I can tell you that we all have security clearance. We are well aware of sharing classified information as being highly inappropriate. In fact, I don't go to classified briefings so that I'm not in danger of sharing classified
Ditto.
information. Normally, you can read more about it in the New York Times than you get in a classified briefing anyways. You know that.
Well, you and I agree 100% on that one.
So, but here is the item, and I think it fundamentally gets to the core of why we need the documents.
Thank you.
Lady Justice should have a blindfold. There are accusations that have been made. In fact, there have been documents that I have read that give me great concern that Lady Justice didn't have a blindfold. It was who you were connected to, who you knew, and certainly you nor I would stand for that. And it is Congress's unique role to provide oversight of the executive branch, not just through the appropriations, but through our constitutionally mandated powers to do that. And so I think that that's why they're critical. I don't see them as mutually exclusive.
I absolutely agree with you on the point that Lady Justice should not be compromised on who you are or who you know. Is the reason when, CHP pulls me over on the highway for, going over the speeding limit, I never say who I am.
They're always wrong. I'm sure they're always wrong when they pull you over.
I go to traffic school and pay my citation and never agree to being guilty. But that's not here or there. I think you could understand the frustration from the minority when we have also asked for information as to the conflicts of interest of this administration, as to the family of the president, specifically in the last incident with Ivanka Trump in China. As soon as China gave her 7 trademarks, the president then vowed to save ZTE. But yeah, there was no outrage, there was no call for an investigation. Mar-a-Lago properties, the number of foreign dignitaries and lobbyists that are coming in and staying in the property, making purchases with unregistered or bogus businesses, that is also a great concern. Where are we going? Where is our economy going? And how does the president money-making schemes and his family's money-making schemes complicate our economy and the small businesses for example, in my community? I have the only steel mill of its type still standing in my district in California. I don't know if they're going to be able to survive this new tariffs that the president is imposing. So I think that when we look at conflicts of interest and when we look at the potential security of our nation, we ought to be looking and focusing on all of it and not just part of it. And I would hope that we could respect this investigation, and at the end of the investigation, I would not be opposed to demanding information, documents, and even doing another investigation should you choose so. Like the ongoing investigation with the Hillary Clinton emails. But yet we discovered that the Trump administration, they are also utilizing their personal email. But yet there has been no outcry from the Republican Party, from the Republican caucus, to investigate that. So we focus on one thing, but we fail to focus on the other. Until we have the tax returns in front of us, we have no idea the kind of mess that this administration is creating for the American taxpayer. And I yield back.
Gentleman yields back her time. Thank you very much. Distinguished gentleman from the state of Washington.
Mr. Chairman, thank you. Thank you, gentlemen, for being with us this afternoon. All of us take very seriously every comment I've heard from both sides of the aisle, I think reflect the fact that we all take seriously one of our biggest obligations and responsibilities. In fact, probably our biggest duty as members of Congress is to form oversight over federal agencies. And so I applaud your efforts to make sure that we are able to perform those duties. In order for us to be able to do that, we have to have cooperation from those agencies. And so not just the Department of Justice, but every single department. And that's a key part of us being able to perform that important function. So I don't have a question. I just wanted to applaud you for making sure that the system works.
I thank the gentleman.
And that we can fulfill that obligation that our constituents expect us to fulfill. And with that, I would reiterate some of the thoughts of Dr. Burgess. My constituents would, I don't know if they care where this leads, other than they want to know the truth. What happened? Sure. And let the chips fall where they may at that point. But the American people deserve the truth. And so thank you for helping to keep agencies' feet to the fire. With that, Mr. Chairman, I'll yield back.
Thank you very much, distinguished gentleman from Freedom, Colorado.
Thank you, Mr. Chairman. First, I'd like to congratulate my friend from Colorado on his primary victory. Mr. Polis won last night in convincing fashion, and I think that deserves congratulations. Next, I'd like to answer my friend from Florida's question, if I may. As a federal prosecutor for 15 years, I had a number of securities fraud investigations that I was looking at, and the SEC had parallel investigations. There were times where the SEC suspended their investigation and allowed us to go forward because many of the witnesses were taking the Fifth in the civil depositions. There were other times where they continued to go forward. I had a number of environmental crimes investigations where the EPA was looking at civil actions and we were looking at criminal actions. So it is not unheard of for it's actually the same branch of government, but different agencies to be looking at a criminal case and a civil case at the same time. I had the great honor during my first trip to Washington, D.C. To work on the Hill, to work for the second best congressman from the state of Wyoming with the last name Cheney on the Iran-Contra investigation, and am well aware of the pitfalls of trying to give someone immunity in a hearing in Congress, and then the prosecution is overturned in the courts because that immunity, it was determined that immunity was, the person could not receive a fair trial as a result of getting that immunity. So there's certainly issues that arise. But I do take a great exception with Mr. Nadler's comment that the purpose of this inquiry is bad faith or defamation. And I will certainly correct myself if that's not what the gentleman said, but that's what I heard. Sometimes the gentleman speaks in New York and I hear in Colorado, and so there is a miscommunication. But I have to tell you, the Inspector General investigated this very matter. And the Inspector General asked for and received 1.2 million documents. Though that is the number of documents and the documents that have been requested in this case. So we're actually asking for a subset of the documents that have been requested by the Inspector General. I don't believe the Inspector General acted in bad faith. I don't believe he intended to defame anybody in his inquiry. And in fact, as Mr. Nadler knows, the procedure when there is a document production, request for production of documents, is to give a list of the documents that you are producing and a list of the documents, a description of those documents that you're not producing, and identify why you're not producing those documents. So if there was classified information, the Department of Justice can simply say, we are not producing this memo from the CIA to the FBI because it contains classified information. If there is a work product privilege where an individual involved at the FBI was involved in drafting a memo or drafting a charging document, They could certainly assert a work product privilege and identify the date of the memo that's not being turned over. But that's not what's been done in this case. What's been done in this case is documents have been withheld, and largely withheld because they hurt. And that is not a rule of evidence that we recognize in the courts, in the executive branch, or in the legislative branch. The fact that something is damaging is not reason not to turn it over. And but for the Inspector General's investigation, we would not know critical information that we need to know for our oversight. And the Inspector General, his budget, Inspector General Horowitz's budget is determined by the very department that is being investigated. So I think we have oversight authority that is independent of the Inspector General and really supersedes the Inspector General's authority. So I just disagree with the idea that this is in some way bad faith. I wanted to ask my friend from Ohio, Mr. Jordan, whether he believed that the Inspector General acted in bad faith. Okay. You may have to speak into the microphone for...
No, I do not.
And would we have known, but for the Inspector General's investigation and but for the Inspector General's review of these 1.2 million documents, would we have known about the bias that existed in the FBI concerning the investigation of the Hillary Clinton email matter?
No, we would not.
And did that bias include texts that came from Peter Strzok in his conversations or his text messaging with another FBI employee, Lisa Page?
Yes.
And did those texts include statements like, OMG, he, referring to Trump, is an idiot?
Yes.
Trump is a disaster. I have no idea how destabilizing his presidency would be. Did he also text, just went to a Southern Virginia Walmart. I could smell, in capital letters, the Trump support. I am riled up. Trump is an effing idiot, is unable to provide a coherent answer. He also testified, or also texted after the election in 2016, a victory by Mr. Trump remains possible. Oh my God, this is effing terrifying. This is effing terrifying. Did he say all those things?
Yes, he did.
And what was his role in the investigation?
He was the lead investigator on both the mid-year exam and the lead agent on the Russian investigation.
He was the lead agent on the Russian investigation. Is there any evidence that he informed Mr. Mueller that he had these opinions of Mr. Trump when he agreed to take the position as lead investigator?
I don't know of any.
Were other members of the investigatory team showing the kind of bias that Peter Strzok showed in these text messages?
Oh, yeah. And Mr. Horowitz is clear about this. It's not just Mr. Strzok and Ms. Page. It's Agent 1, Agent 2, and FBI lawyer number 2. And all five face, actually all five, well, Lisa Page is left, but the other 4 face disciplinary action at the FBI.
And so the documents that you're requesting are documents that, one, talk about the bias. And by the way, I mentioned some things that he said that were negative towards candidate Trump. Did he also make comments in text messages that have been revealed as a result of the IG's investigation that were positive about Secretary Clinton, candidate Clinton at the time?
If you mean that she should win 100 million to 0, that he felt not one single American should vote for President Trump, then I would say yes.
Okay. So is that bias that has been shown a fair investigation issue for Congress to look at in its oversight capabilities or oversight responsibilities?
I certainly think so.
And is that the purpose, not defamation, not bad faith, but is that the purpose of the documents that have been requested by these requests that both you and Mr. Meadows are making?
Yeah, it certainly is, but it's not just the fact that there was bias, and I know the gentleman understands this. It's one thing to say Trump is awful. It's another thing to say we will stop him. It's one thing to say we want him to lose 100 million to zero. It's another thing to say we have an insurance policy and we will stop him, and to utter those statements just weeks after you've opened an investigation into President Trump or then candidate Trump.
Is the individual or individuals that made the decision on what lines of inquiry to pursue, what documents to review, how to interpret the documents being reviewed, were those individuals, the individuals that we're talking about that demonstrated this bad faith towards one of the parties being investigated?
Yes.
And I can tell you, Mr. Chairman, I have spent 25 years as a prosecutor, and I have never seen the kind of bias and never allowed someone with this kind of bias to be involved in an investigation of a subject or target. I think it's unbelievable that the FBI has not issued an apology to the American people for what has happened in this case.
Mr. Chairman,
And
can I comment?
Yes.
Excuse me, just a moment. Does the gentleman wish to engage the gentleman, or is he yielding his time?
I am happy to recognize the gentleman from New York.
Thank you.
If he speaks slowly.
I don't know that that request has been made of anybody in Congress since Barney Frank. Mr. Buck, let me just point out a few things. First of all, the text messages by Mr. Strzok and Ms. Page have been characterized as bias. They've been characterized as political opinion. I've never heard them characterized until this moment as bad faith. They were their political opinions, period. And you can call them bias if you want, but they were their political opinions being expressed between two individuals. I'd further point out that the moment that the special counsel found out about this, he removed Mr. Strzok from the investigation. The moment he found out about these texts, Strzok was removed from the investigation. Thirdly, the Inspector General found, as a matter of fact, positively, that made several findings, two relevant findings. One, that Strzok did not bring his political bias, political opinion, to the office in effect, that it did not affect any of the decisions he made. And secondly, that the decisions he made the decisions, I should say, he participated in were made by a number of people, and that he found, as a matter of fact, the Inspector General found, as a matter of fact, that those decisions regarding the investigation, all of them, were made without bias and without being infected or affected in any way by the political opinions or biases, if you wish, of Mr. Strzok. I should just say on a different level, as far as I can tell, the only thing wrong that Mr. Strzok did was use an FBI cell phone to communicate with his girlfriend. FBI agents, like anybody else, are entitled to their political opinions. There are plenty of FBI agents, I'm sure, who were pro-Hillary. There are plenty of FBI agents, I'm sure, who are pro-Trump. The FBI is prohibited by law. The Department of Justice is prohibited by law from asking political opinions of people they're going to hire. It's a violation of the Hatch Act. And frankly, the only legitimate question is whether the political opinions of Mr. Page, Ms. Page, Mr. Strzok, or anybody else affected the decisions made in the investigation. The finding of the Inspector General is they did not, and there's no evidence to the contrary.
I'm going to reclaim my time for just a moment, if I can, and quote from the Inspector General's report. In fact, the Department of Justice Inspector General Horowitz stated that Strzok's texts were not only indicative of a biased state of mind, but even more seriously, implies a willingness to take official action to impact the presidential candidate, Donald Trump's, electoral prospects. This is antithetical to the core values of the FBI and Department of Justice. That's a quote from his report.
But his report also goes on to say, number one, that the moment this was found out, he was let go from the, I shouldn't say let go, he was removed from the investigation. And number two, that there's a different, although he may have indicated, although the Inspector General said what you just said, namely that it indicates a willingness, which is to say a state of mind, he makes a finding of fact that it didn't happen. That, in fact, whatever his state of mind, whatever his willingness, they did not affect his participation in the decisions or the decisions themselves.
Mr. Chairman? I've the utmost respect for the gentleman from New York, but that's not accurate, and the gentleman from New York should know that, because when he specifically questioned Mr. Horowitz last week, Mr. Horowitz answered, with respect to the mid-year exam, that's accurate, but not with respect to the start of the Russian examination, to the Russian investigation. So to say that his bias didn't play some role in the both investigations is not accurate, and you should know that because he made that statement. Inspector General Horowitz made that statement when you questioned him last week.
Mr. Chairman, I think we're beating a dead horse to a certain extent, and I appreciate the chairman's willingness to engage in this line of inquiry, and I yield back my time.
Gentleman yields, distinguished gentleman yields back his time. The distinguished gentlewoman from Wyoming does not seek time. Gentlemen, I think we've gotten closer to understanding that each of you were given an opportunity to speak today, whether I agree or disagree with you. By the way, I disagree with some of the comments that are made because I believe that appearance is a big factor of bias. And as you know, my father was the director of the Federal Bureau of Investigation and believed that appearances were most indicative of trying to be fair. So I will take that perspective. We can all offer our own evaluation. So I want to thank you for being here. I'm sorry that the gentleman, Mr. Perry, could not come back, but I appreciated having him today appear as he did. And I want to thank each of you very much for being here today.
Thank you, Mr. Chairman, and the entire committee.
Yes, sir. Thank you. Okay, we have now heard this testimony. Is there any other member that would seek to give testimony on this House resolution? Seeing none, this closes the hearing now before H.Res. 970. Chairman being received a motion from the distinguished gentleman from Georgia.
Thank you, Mr. Chairman. Mr. Chairman, I move the committee grant H.Res. 970. The insisting that the Department of Justice fully comply with the requests, including subpoenas of the Permanent Select Committee on Intelligence and the subpoena issued by the Committee on the Judiciary relating to the potential violations of the Foreign Intelligence Surveillance Act by personnel of the Department of Justice and related matters, a closed rule. The rule provides 1 hour debate equally divided and controlled by the chair and ranking minority member of the Committee on the Judiciary or their respective designees. The rule waives all points of order against consideration of the resolution. And finally, the rule provides that the resolution shall be considered as read and shall not be subject to a demand for the division of the question.
Thank you very much. You've now heard the motion from the distinguished gentleman from Georgia. Is there amendment or discussion to that? Seeing none, the vote will now be on the motion from the distinguished gentleman from Georgia. Those in favor signify by saying aye. Aye. Those opposed, no.
No.
Ayes have it, ayes have it.
Mr. Chairman, we could ask for a roll call on this closed rule.
Mr. Cole. Mr. Woodall. Aye. Mr. Woodall. Aye. Mr. Burgess. Mr. Burgess. Aye. Mr. Collins. Aye. Mr. Collins. Aye. Mr. Byrne. Aye. Mr. Byrne. Aye. Mr. Newhouse. Aye. Mr. Newhouse. Aye. Mr. Buck. Aye. Mr. Buck. Aye. Ms. Cheney. Ms. Cheney. Aye. Mr. McGovern.
No.
Mr. McGovern. No. Mr. Hastings. No. Mr. Hastings. No. Mr. Polis. No. Mr. Polis. No. Mrs. Torres. Mrs. Torres. No. Mr. Chairman.
Aye.
Mr. Chairman. Aye.
Clerk will report the total.
8 yeas, 3 nays.
The motion is agreed to. Accordingly, the distinguished gentleman from Georgia, Mr. Collins from the Judiciary Committee, will be handling this rule.
And I'll handle
the Rules Committee.
And I'll handle it for the Democrats.
And the distinguished gentleman from Massachusetts will be handling this for Democrats. I want to thank each of our members for their attention to detail. Evidently, the gentlewoman from California is seeking my attention. Yes, ma'am.
Just a question, if we're going to see any bill tomorrow on the separation of the children?
At this time, we do not have any bill that is scheduled at the Rules Committee. Excuse me, thank you very much. I was just advised that evidently the clerk needs to please advise me of the vote total.
8-4.
8-4, and then we have approved that. Thank you very much. Was that my fault? I don't know whose fault it was. I'll take the fault. Thank you very much. The gentlewoman has asked if there is any other time that would be scheduled that would be here, and that answer is nothing is expected to be scheduled. Is there any other question for the committee? I want to thank the committee very much. We've now finished our work for the day.